for joining this Africa Construction Law webinar on mitigating the risk on crude oil pipeline construction projects. My name is Ilham Kaburi. I'll be your moderator for this event. Before I go on to introduce myself, the ACL, and the webinar today, a few housekeeping matters. First of all, I would be grateful if you could all mute yourself and hide your cameras, at least until we get onto the last part of the event, which will be the discussion and Q&A. Then you'll be invited to come on your cameras. I would also suggest that on the top right corner of your screen, you use the speaker's view so that you can see each of the speakers' slides during the presentation. And finally, the last housekeeping matter. At the bottom of your screen, you have a chat window. I will be monitoring the chat during the presentations. So feel free to drop questions, comments. We will try to pick a number of those to be discussed at the end of the event and at the end of the webinar and put to the panel. So now that the housekeeping is out of the way, let me introduce myself and tell you a little bit about Africa Construction Law, the organization under the auspices of which this webinar was put together in association with Angwalia Buziku Advocates, Uganda, LMS Legal LLP UK, I Resolve Tanzania, and Zonglin, China. My name is Ilham Kaburi. I'm an associate in the International Arbitration, Construction and Engineering subgroup of Hogan Lovells, based in Dubai, United Arab Emirates. Originally, I am from Morocco, so I am indeed of African descent. Today, I'm speaking to you wearing not my Hogan Lovells hat, but my Africa Construction Law hat. I sit on the Global Steering Committee of Africa Construction Law and head the Francophone Africa team. So Africa Construction Law, what is it for those who are not familiar with the organization? Africa Construction Law, ACL in short, is a Pan-African initiative set up by construction law practitioners across Africa and in the diaspora to promote thought leadership in the in the field of construction law and practice in Africa. ACL is managed by a global steering committee made up of construction practitioners from more than 20 African countries based in Africa and outside of Africa. ACL is also run under the guidance of an advisory board comprising of leading and senior construction law experts from diverse backgrounds who are also based in Africa and outside of Africa. ACL was created in 2020 and launched in April 2021 during a one-week-long series of events focused on construction law and practice in the different regions of Africa. So this is ACL's first webinar following the launch, and we're really excited about this one, which is about mitigating risk on crude oil pipeline construction projects with a focus on the East Africa crude oil pipeline as a case study, which I will call ECOP in short. So ECOP is the project that resulted from the discovery of oil in Uganda in the Lake Albert in 2006. Once a country discovers oil, the second thing to think of is how to transport it to a port. And like Uganda, it is a landlocked country to a port to a neighboring country. So in 2016, 2017, Uganda was in talks with its neighbors, Kenya and Tanzania, to try to find the best route to build the pipeline to the coast. Can I ask everyone to mute themselves? Thank you. Uganda then decided to go for the lowest cost option for transporting crude oil to the East African coast, which was on the Tanzania route. And that basically gave rise to the ECOP project. The ECOP project stakeholders are total China National Offshore Oil Corporation, the Uganda National Pipeline Company, and the Tanzania Petroleum Development Corporation. ECOP is a $3.5 billion project with a 36 months construction project duration. Once completed, it will be the longest heated crude oil pipeline in the world. So that's the introduction of the case study we have today, but the speakers will go in much more detail than me on all areas of the contractual matters that arise out of such a massive project. And this leads me to introducing the first speaker today, who's Virginie Colaiuta, and who will walk us through typical risk on pipeline projects. Virginie is a partner in the London office of LMS Legal LLP. She acts as counsel, advocate, and arbitrator in international arbitration proceedings deriving from construction and energy projects. Virginie is admitted to practice in England and Wales, in New York, and in France. She also teaches investment treaty arbitration in relation to construction projects at the Construction Law Centre of King's College London. She is the chair of the editorial board of the law magazine Construction Law International, a publication of the International Construction Projects Committee of the IBA. She is also recognized as a thought leader by Who's Who's Legal and recommended as an expert by Legal 500 in this field. Virginie, over to you. You have 20 minutes, taking us thus to 10:31 in London.
Thank you, Ilham. I will share my slides for my presentation, and you should be able to see them now in full screen. Every construction project is different and therefore presents a variety of different risks. To ensure the success of a project, a contractor must be able to recognize and assess those risks in advance and then manage them. For employers and contractors, the risks associated with pipeline projects may relate to different aspects, and I have made a selection of the aspects that I will analyze during my 20 minutes presentation. Those risks are related to design, contractual arrangements, delays, geological and ground conditions, health and safety, governmental regulations and sanctions, and protection of foreign investments that may lead to investor-state disputes. Many risks arising during the operational phase of a pipeline could be anticipated and controlled at the design stage. And the most common omissions at the design stage relate to lack of defined safety limits for operating pressure and temperature, the minimum and the maximum temperature and pressure, lack of clarity on the specifications of the type of product to be transported, selection of an inappropriate pipe material for the fluid to be transported, failure to consider external factors that may affect pipeline maintenance and emergency procedures, and no quantified safety risk assessment. The possibility of any future changes in the fluid to be transported should be considered at the design stage, but sometimes this is not the case. Risks may be increased also in relation to the design if the pipeline changes ownership or operator. The allocation of pipeline design risks in the contract should be clear, and this is not always the case. And specific regulations may apply to pipeline design. An example is the UK Regulation 5 of the Pipeline Safety Regulations of 1996. I'm not going to indulge on the aspect of regulations because my colleagues Daniel Langwalia and Madeleine Kime are my co-panelists who will actually refer to the regulations that apply to the EACOP project in relation to Uganda and Tanzania. Other risks are contractual, and the contractual risks are relating to the lack of clarity of the contractual obligations of each parties, and an imbalance in allocation of liability. We have seen in the last decades that there is a very dangerous trend of pushing down the liability towards the supply chain. And that imbalance of allocation of liability can in fact increase the likelihood of dispute and the unsuccess of the project. And unfortunately, there are many employers who are unable to resist that temptation and creating in that way more risks for their project overall. Other risks derive from implied terms. Implied terms are those contractual definitions of contractual obligations that derive from the governing law provisions, which are not necessarily reproduced in the contract, but nevertheless apply to the obligations of the parties. Typically, the contractual clause that create major risks for either parties is are those relating to the change orders and variations, and the making and pricing changes to the contractor scope of work can be in fact disruptive and can impact the cash flow and the resources for the project. Project payment clauses are also the source of much controversy between the parties, and many difficulties relating to late payments can be the result of disputes and ultimately lead to a breakdown in the relationship between the contracting parties, insolvency of the companies involved, and also the failure of the project. The definition of those payment conditions are important, and sometimes they are not considered as with the due attention. The contractual risks derive also from national regulations that affect payment terms. An example is the one from the United Kingdom, the Construction Act 1996, which contains mandatory provisions regarding payments. And so the right of the parties to a construction contract to payment by installments, stage payments, or other periodic payments if the duration of the work is less than 45 days, the right of the parties to suspend performance of any or all of their obligations in the event of non-payment, and the prohibition of certain conditional payment clauses, such as paid when paid clauses, that is a clause making payment under a construction contract conditional on the payor receiving payment from a third person. As I said, the regulations that apply to the ERCOP project are those relating to Uganda and Tanzania. But very often, the contracts for major projects, such as the ERCOP project, maybe, are subjected to the laws of the UK or the laws of France. It is mainly in the Francophone African countries that French law is often chosen as the governing law of the contract, and English law as the governing law of the contracts applicable for projects in the Anglophone countries in Africa. So for that reason, the reference to English and French law is made in my presentation because they might be relevant for the contracts relating to pipeline projects and in particular to ERCOP projects. The contractual risks means also allocation of risks. And as I said, a balanced risk allocation may increase the success of the project. And a risk in principle should be allocated to a party if the risk is within the party's control. The party can transfer the risk, for instance, through insurance. Placing the risk on the party is in the interest of efficiency, including scheduling, incentivizing, and innovating. If the risk materializes, the loss falls within the party bearing the risk. And these are the principles that should, in fact, inspire the allocation of risk. But as we know, it is that allocation is determined by contractual negotiation. And sometimes that contractual negotiation brings leads to the pushing down in the supply chain those risks. Depending on the contract structure that is chosen, that allocation is affected. In a traditional procurement contract, the design and the building of a project is often separate. And typically the employer assumes liability for the design and the contractor is entitled to remedies for design defects. For example, for extension of time, for completion and increased payment. In a design and build contract, the contractor will be responsible for both the design and the construction according to the contract specifications. And this provides the employer with a single point of responsibility and simplifies the allocation of liability. And finally, in engineering, procurement, and construction, the EPC contract, the contractor would usually assume responsibility for all elements of the design, construction, and procurement of a project on a turnkey basis. And in these EPC contracts, the contractor may have significant discretion to design the project, provided that the functional or performance-based specification requirements are met. Obviously, these are just some main examples that are quite often relied upon, but they are not exhaustive examples. As a way of determining the contractual obligations of the parties, it's very important to refer also to implied terms. And those implied terms derive from the governing law. Just to give you an example, depending on whether the contract is governed by English law or French law, you would have as a result, the application of the principle of imprévision or not. For example, under French law, the principle imprévision allows the party to be excused from its contractual obligations as a result of an imbalance of the onerosity of its contractual performance as a result of an unforeseen event. The equivalent concept of hardship under English law is not applicable unless the parties have specifically agreed and negotiated a hardship clause in their contract. The same thing happens for force majeure. Under French law, force majeure is a principle that would apply as an implied term to the contract. This is not the case under English law, and the events that would be referred to as force majeure will be defined in the contract itself by the parties as a result of their negotiations. Other implied terms, for example, under French law, related to the decennial liability of any construction, which is mandatory. Such a decennial liability does not exist under English law. And also there are liability deriving from ground conditions in the sense of the structure of the construction itself. Under French law, there is a liability determined, imposed on the contractor, which does not necessarily exist under English law. Another aspect of risks, which is very, very typical in any construction project and which includes also pipeline projects, are delays. Delays increase time of completion and also cost. It's a source, a typical source of construction disputes, and can enable the employer to claim liquidated damages against the contractor as defined in the contract, and also can result in increased cost that the contractor may seek to recover from the employer, especially if the delays have been caused by the employer or by events beyond the contractor's control. For pipeline projects, geological risks and ground conditions are very important. They may affect time and cost and the integrity of the construction structure and the outcome of the project. They can disrupt, in fact, totally the project. In the UK, the approach is that the construction contractors and subcontractors are expected to make reasonable inquiries to ensure that the ground is suitable for the project. And an example, governing example, is deriving from the case Van Oord UK against Allseas, where the court held that every experienced contractor knows that ground investigations can only be 100% accurate in the precise locations in which they are carried out. It is for an experienced contractor to fill in the gaps and take an informed decision as to what the likely conditions would be overall. Accordingly, by reference to the ground information available to, in this case, it was a subcontractor, the court concluded that if there were different conditions from those described in the contract documents, there were conditions which could reasonably have been expected to have been foreseen as different by an experienced contractor. So the result is that under UK law, it's quite difficult to define what could be considered as unforeseen ground conditions. Under French law, the approach is different. It's defined by Article 1792 of the French Civil Code, which provides that any builder, any contractor of a construction is liable as of right towards the building owners or purchaser for damages, even resulting from a defect of the ground. So that means from the ground conditions, which imperil the stability of the building, or which, by affecting it in one of its constituent parts or one of its equipment items, render it unsuitable for its purposes. Such liability does not take place where the builder proves that the damages were occasioned by an extraneous event. The Article 1792 is a mandatory provision and applies even when the contractor is not responsible for the design. So the contractor must ensure on its own, for its own sake, that the ground conditions will not impair the structure of the construction realized. Other risks are obviously relating to health and safety, which are very, very important. And they usually relate to poor safety procedures, unsuitable equipment, lack of training, and lack of resources. Lack of resources, each of these projects, each of these elements are susceptible to apply to any project, and that should be in fact taken seriously into consideration also for the ERCOP project, according to the standards applicable in Uganda and Tanzania. Other relevant risks are the governmental regulations and sanctions. As I said, my co-panelists Daniel and Madeleine will explain those regulations in relation to Uganda and Tanzania. I make some example here in relation to the UK Petroleum Act, for example, that establishes some impositions in relation to the licensing of pipeline projects. But what is actually the example, which is mostly, it's very interesting, is the fact that some states can impose sanctions outside of their own territories for political reasons. And this is an example is given by the United States countering America's adversary through Sanctions Act, the CAATSA. This is a regulation, an American regulation, that applies to a pipeline taking place in the Baltic Sea from Russia and Germany, where sanctions have been defined by the United States for any contractors or subcontractors involved in that Nord Stream project. Even though that pipeline project is not built within the American territory, so it is within the territories of controlled by the countries which have been involved in that project. But nevertheless, the United States have established sanctions for any involvement of the companies in that project. And many contractors and subcontractors who have been working on that project were not necessarily totally informed of the risks and consequences for just selling equipment or being involved. And finally, there is the risk of investors and states disputes that may derive from bilateral, multilateral investment treaties. An example is the Trans-Canada Corporation and Trans-Canada Pipelines Limited against the United States. This was an ICSID case, the international case where two Canadian companies applied for a permit to build an oil pipeline that would cross the border between Canada and the United States. The policy of the United States was to accelerate the development of energy production, including pipelines. Sorry. If the State Department had determined that the pipeline was in the interest of the United States, it would issue the permit. However, the applicants argued that for political reasons, the State Department, the US State Department refused to expedite its application and ultimately denied it after 7 years. Claimants initiated a NAFTA case proceedings against the United States in 2016, claiming that the delay in processing their claim caused significant damages. And eventually, the US administration approved finally the Canadian project in 2017. And accordingly, the investor and the US government agreed to discontinue the NAFTA claims. So I hope you have had the opportunity to see the variety of risks that can derive from a pipeline project. And I leave my co-panelists to continue to explain the details of them.
Thank you, Virginie, for your helicopter view on contractual risk in the context of pipeline projects. I can see some background noise. Is everyone on mute? If you're not, can you please mute yourself?
I think Yan Tan is not muted. It would be great if she can actually mute herself. Yan Tan? I don't know if you can hear me. Is your connection?
Thank you, Virginia. I think there is no more background noise now. So we're saying thank you for your helicopter view on contractual risk in the context of crude oil pipeline projects, which leads us nicely to the second topic on the agenda: EPC contract splitting, related tax planning, and disputes adjudication board, which will be covered by Mr. Jinlin Nan, who is a partner in Songlin Law Firm, Shanghai, one of the largest law firms in China, which was founded in 1993 and counts over 2,200 professionals across 18 offices. Jinlin is one of the leading lawyers in China advising on overseas construction and infrastructure projects. He specializes in providing clients with comprehensive legal services throughout the whole process of conducting construction projects overseas, from the planning of the investment to the handling of disputes. He advises on construction claims in the context of litigation, arbitration, and other forms of ADR. Jinlin, over to you. You have 20 minutes, which will take us to 5 to 6 a.m. in New York. I'm very sorry for making you speak that early. Over to you, Jinlin.
Okay. Good morning, everyone, and good afternoon, everyone. So pleased to be with you to have this topic. Today, I just want to share with how the investor can reduce the investment and how the parties concerned to prevent any dispute, disagreement become dispute. So let's have a look at my PPT. Oh, sorry. Why? Yes. Today, the first topic is EPC contract splitting. As we know that EPC contract, as Virginia just mentioned, one of the form. Once the project financed by any international financial institute, the financial institute require that a single person or single contractor should be responsible for the progress of the work and the quality of the work. Under such a situation, EPC contract would be more than less recommended by the financial institutes. So under such a situation—
Jinlin, sorry to interrupt. Can I ask you to put your slides on slideshow so it's going to be bigger for the participants? Because it's relatively small.
Oh, yeah.
Thank you so much.
Oh, thank you so much.
That's much better. Thank you.
Okay, so under such a situation, the financial institution often require the employer or the borrower to sign EPC contract so that they can find a single person to be responsible for the work and for the progress of the work. Under such a situation, EPC contract would be signed by the two parties, employer and the contractor. But we know that the work actually can be divided into two parts. One is onshore, which is including partial design, installation, testing, commissioning, civil work, and another is the import part, because I think most of the raw materials, such as pipeline, pumps, and would be imported overseas. Under such a situation, more or less, contract would be break down into onshore contract and offshore contract. Onshore contract, just as I mentioned just now, that it's regarding the civil work. Offshore would be the supply of the procurement. So as everyone knows, EPC means engineering, procurement, and construction. So construction would be on-site, procurement would be offshore. And maybe some people may ask why the contract should be split into two parts. Actually, if we sign one contract with onshore company, then the contract price would subject to the tax, local tax. If we split into two parts, then the offshore part would be under the international trade term, which just subject to duties, not subject to any local taxes or income tax or other taxes. So that's the reason why normally the contract is split into onshore and offshore contract. Let's look at the structure. The employer would sign EPC contract with EPC contractor, and the EPC contractor will do the engineering work, which means design, procurement, which means buying the equipment, material, and raw material or framed work, and construction. Construction means civil work. Civil work, of course, may be divided into many parts, not only one single work, many parts. So it would be under the civil work, you may subcontract the work to different subcontractors. So splitting EPC contract into two or more separate contracts of offshore and onshore as per following: place of the construction activity, technology requirement, tax and foreign currency control. All goods and equipment should be purchased under the term of international trade. We should pay great attention not only to the tax, but also to foreign currency control. For some country, when foreign currency paid into the boundary of the jurisdiction, they compulsory or mandatory required to convert into local currency. And in many African countries, the currency is not so stable. Exchange rates fluctuation very great. So actually, the cost, the implied cost would be increased. So under such a situation, offshore part would be paid by the international recognized hard currency. Onshore part may be paid by local currency to pay the local onshore work and local procurement. And so this is a strongly recommended method to split the contract into two in onshore and offshore contract. But normally the contract would be start from EPC contract and the bidding process from EPC contract. And they have several terms of negotiation, and the last term of negotiation, normally the employer require the EPC contractor to split it into two parts. In case they cannot match, the two parts cannot match, they will have a boiler player under the two contracts. So under such a situation, to guarantee that nothing can be left over by splitting of the two contracts. So this is a normal practice, but the important thing is that the owner of the project, just as just mentioned, the four parties, the owner of the project must recognize this is a way to save the investment, and this is a way to build the project even better, because the money the project, the sponsor or the shareholder invested in it, or money borrowed from the bank, will not go to the pocket of the governments, but go to the projects, because after completion of the projects will benefit for the two peoples, the governments, for the tax in the future, but not at the beginning. Just like an infant person, you cannot give an infant person too much burden when they are growing. After grow up, then you can give him some burdens. Just this is an example. So also this can promote cooperation to different professions, because when split into it, and professionalized companies do the professionalized work. For instance, Chinese contractors are good at civil work, and Western suppliers or manufacturers are good at manufacturing. So in this way, can use the best resources of each party in the group, and also optimize the tax structure of the employer, because of course, at the end, the employer should have a tax optimization structure, which will be consulted by such as consultant institutes. But this is the shortest way to reduce a large amount of tax. Also, reduce taxable amount by local authority, just as I mentioned. Also prevent any exchange rate fluctuation and foreign currency control. As I mentioned, this is also always happen in African country and South American countries, because the local government has foreign currency control. That is one thing. The more control, the more fluctuation would occur during the developments of the projects. So under such a situation, if we split the contract price into two parts, one part is onshore, which is paid by local currency, which will be influenced by the fluctuation of the foreign currency and fluctuation of the rate. And this is a small amount. But the largest share of the price would be offshore. But offshore paid in foreign currency, and the contractor, offshore contractor received the hard currency, and the offshore contractor paid with the hard currency. Also keep in mind, offshore contract account, receiving amount, the bank account should be kept offshore in the offshore account, bank account, not onshore. If onshore, it will also fall into the subject of taxation of local jurisdiction or tax law. So this is actually a technical method for either the contractor or the employer or the subcontractor, because in the future, even the subcontract may be split into two parts, onshore and offshore. This is the method. And then general structure. I will give you a quick shot. As host employer, host country, EPC contract with EPC contractor, product coordination agreement. Some people call it umbrella agreement. Some people call it boilerplate agreement. Then EPC members will sign, of course, because the investor, promoter, or shareholder of the employer would like to take the work of EPC contract. So some member will have onshore, some will have offshore contract. And onshore part would be civil work agreement. Offshore would be engineer and procurement. Most part of the engineering work may be done in offshore work, so outside of the jurisdiction. But the workshop design and some detailed design must be done at the locally. So under such a situation, maybe the design can be split into also two parts, offshore part and onshore part. And onshore part, for the onshore part, beside the civil work, there must be installation, erection, and labor, and testing, commissioning. Of course, in the future, operation and maintenance. So some advices on EPC contract. Before signing the splitting of EPC contract, the employer should get the employer's consent or get the permit. Without the permit, you cannot do the work. After EPC contract split, attention should be paid to coordination of the work scope and work schedule, even though there is project coordination agreement. Different splitting strategy would be adopted under different tax environments in different countries. Taking tax planning and foreign exchange risk into consideration, limiting compensation liability for delays under different contracts, preventing contract termination risks in different contracts. This is regarding how to split, why to split EPC contract into onshore, offshore part, and how to split, what advice should take from legal point of view. The next part would be another one, how to prevent disagreement become dispute. And if any project supported by International Financial Institute, the financial institute normally require to keep FIDIC contract term 20.4 DB item there, because this is an efficient way to prevent any disagreement become a dispute. Everyone knows if a project fails, the biggest loser would be the financer, either project finance under project financing, or by corporate financing, or by buyer's credit, unless by seller's credit. But for such huge project, normally do not adopt seller's credit, normally takes recourse or no recourse project finance way. So under such a situation, the financer require one is EPC contract, another keep DAB or DAAB. Under FIDIC term 2019, it's called DAAB, but previous term called DAB there, because when they start or the commencement of the work occurs, DAB should be on site, on the duty. So it is an alternative dispute resolution. And this is also subject to agreement. It's agreement not only between the DB member and contractor and employer, but it's also must subject to, this agreement must be submitted to the financer. Procedure for international arbitration as per FIDIC condition. As we know that any dispute submit to international arbitration, they have pre-procedures such as DAB's judgment, more or less a decision from DAB, even though it's not binding, but when arbitration occurs, arbitrators more or less concern the DAB's opinion, because DAB member were on site, they know more facts, they know more the actual situation that the people report in the arbitration during the arbitration proceeding. So the balance risks between the employer and the contractor. How to balance the risks of employer and contractor? Everyone knows that the position of employer and contractor are different. Employer always upper position and contractor lower. But if DAB involves, the contractor has a place and has some people to claim what the design institute or what the employer or what the local government not coordinate or cooperate with the project progress. Then the DAB member will decide whose fault, and DAB member would push the default party to promote or progress there in the right track. So this is called balance risk of location between employer and contractor. This is an advantage. It is good for the contractor. The party who would be with great power negotiation may request to remove this provision of DB, that is employer. Settle dispute of the project in timely, effect, and fair manner, we advise the employer and contractor shall set up the DAB clause. For the large international infrastructure project funded by World Bank, Asia Bank, and other international financial institutions, the financer may frequently require the party retain provision of DB. Don't appoint DB. That's just I mentioned how the DB member don't appoint. There is a appendix in FIDIC contract how to appoint DB members. Normally they appoint 1 or 3 suitable qualified person have no conflict of interest or no interest with the project. And DB is full-time and sometimes an ad hoc DB member. And I think I still have I have 4 minutes to go. So if anyone has any question or some issues may raise on the 2 things, I may summarize my 2 topics. One is EPC contract, splitting of EPC contract, the reason, how, and advice. Second is how to prevent any disagreement become dispute. We strongly recommend both parties, both employer and contractor, to keep DB clause in the contract, and also you need to consult with financial institutes who provide finance for the project for their opinion, whether they would require such keeping. Or else you signed the contract, the financier said, oh, I'm sorry, I cannot accept such a contract term. You need to revise. That would be lose the time. For any project, You lose the time, you will lose the opportunity, you will lose the money. Time is money for the infrastructure project. Thank you very much.
Thank you, Jinlin, and thank you for keeping well under the 20 minutes. We'll add that time at the end for more Q&A. And thanks for covering not only the key aspects of the EPC contract, but also very important mechanisms that the dispute adjudication board is. And I know you have extensive experience not only appearing before DABs, but also sitting on DABs. So if any of the participants have questions on DABs, please drop them in the chat. We'll pick them up at the end during the Q&A session. So Jinlin and Virginie gave us the international perspective into crude oil pipeline projects, and we will now dive into the laws of the two countries where the ECO projects is taking place, namely Uganda and Tanzania. Starting with Uganda, we will hear from Daniel Angalia, who's managing partner of Angalia, Busiku & Co Advocates, and who will introduce us to local content requirements rules in Uganda. Daniel is an advocate of the course of jurisdiction of Uganda. Daniel represents several local international construction companies involved in various construction projects in Uganda. He has advised on many projects, including the Kampala Northern Bypass project funded by the European Union and the government of Uganda, civil works and rehabilitation of the Ishaka Katunguru 58 kilometers road project, and many others. Daniel is a member of the Institute of Corporate Governance of Uganda, the Ugandan Law Society, the East African Law Society, and a contributing member of the World Bank Doing Business project for Uganda since 2014. Daniel, over to you, and you have 20 minutes, which, if I'm not mistaken, will take us to 1:16 p.m. in Kampala. Over to you, Daniel. Daniel, I think you're on mute. I mean, I can't hear you. Daniel?
Hello?
Yes, now we can hear you. So over to you, Daniel.
Okay. Good morning, good afternoon, or good evening, wherever you may be. I'm going to take you through local content compliance requirements for companies planning to do business in oil and gas sector in Uganda. Following the discovery of oil and gas, it came with the general excitements. The expectations were high. A lot is expected out of this sector. At the end of it all, the question has arisen: how will the locals benefit from this oil and gas project? Hence the concept of national content. So the government has determined that national content strategy in the form of policy and regulatory measures.
Daniel, apologies for interrupting. I think your camera is still off.
Oh.
Apologies for the interruption. Now we can see you.
Oh, thank you. Yes, the government has determined that for the locals to benefit from this oil and gas, there's need to have in place national content strategy in the form of policy and regulatory measures that focus on increasing the use of locally available labor, technology, and other resources in the oil and gas sector. So these measures are meant to be complied with by all companies licensed or subcontracted to engage in the exploration, development, and production of oil and gas in the country. The question is, what is national content? How do we understand national content? The applicable laws the Petroleum Exploration, Development, and the Production National Content Regulations provides a definition of what national content is. Basically, it means the level of use of Ugandan local expertise, goods and services, Ugandan companies, Ugandan citizens, registered entities, and business in the oil and gas sector. Another definition can be borrowed from the 2018 National Content Policy for the petroleum sector in Uganda, which defined this as the value added or created in the Ugandan economy through the employment of Ugandan workers and the use of goods produced or available in Uganda and services provided by Ugandan citizens and enterprises. By way of comparison, the Nigerian oil and gas industry content of 2010 defines it as the quantum of composite value added to or created in the Nigerian economy by a systematic development of capacity and capabilities through deliberate utilization of Nigerian human material resources in the Nigerian oil and gas sector. From both definitions, we're able to ascertain that emphasis is on the use of local expertise, service providers, and local resources in the oil and gas sector. In summary, the extent of use of the local expertise, service providers in the oil and gas sector. So by way of comparison, the same position in Tanzania, in Nigeria applies to Uganda in summary. What then is the justification for the local content? Why do we have this in place? Under the 1995 Constitution of Uganda, all natural resources are held by government in trust on trust or on behalf of the people of Uganda. So there's need to ensure that the utilization of the resources, which is held by government on trust, results into benefit to the locals. So the government has a duty to hold its natural resources on behalf of the citizens. Its utilization should involve the citizens as well. And to contextualize it further, there's need for the social license. If any project of this magnitude is to be carried on, the host communities must participate. So with the concept of local content and incorporating of the citizens or the local communities in the sector, in a way, the licensee or the contractor, subcontractor will be getting a social license from the locals. Without the social license, they may vandalize the intended activities and in the end, frustrate it. The compliance requirements are categorized into 4. One of them is registration of the National Supplier Database. Under the Petroleum Exploration, Development, and Production National Content Regulations, the Petroleum Authority shall develop a national supplier database for petroleum activities. A company shall not provide goods, works, or services for petroleum activities unless it is in the national supplier database. That is the starting point. Having been registered or incorporated in Uganda or any other part of the world, before you can get into the activities associated with oil and gas, you must be registered with the National Supplier Database. The Petroleum Authority of Uganda, the regulatory body for the sector, developed a National Supplier Database, a register of all entities and persons with interest to provide goods, works, and services, the oil and gas sector in Uganda. This registration is done online, and one of the requirements is the evidence of legal status, certificate of incorporation, or certificate of registration. Information on the shareholding and management of the company. You will need a reference letter from the bank or proof of liquidity status, proof of compliance with the tax laws. In the case of Uganda, you'll need tax clearance certificate from Uganda Revenue Authority. Proof of social security compliance, you'll need clearance from National Social Security Fund if you're an entity registered in Uganda. A national content strategy or plan showing Ugandans employed or to be employed by the entity, the goods and services to be used by the company, and whether those goods and services are from Uganda, the extent to which the Ugandans are going to be involved in the provision of the goods and services to the company. That is phase one. Now that you have been registered in the National Supply Database, we assume you have been licensed or you have got a contract from a subcontractor or a licensee in the oil and gas sector. The other requirements, compliance requirements, has to do with the provision of goods and services by Ugandan companies as one of the requirements. The licensee, it is contractors and subcontractors shall give preference to goods which are produced or available in Uganda and services which are rendered by Ugandan companies. So where those goods are not available in Uganda, they shall be provided by a company which has entered into a joint venture with the Ugandan company. As long as the Ugandan company has 48% and above shareholding in the joint venture. The licensee, it is contractors and subcontractors shall also ensure that the Ugandan entities are notified of the upcoming contracts in the sector as early as practicable. In both regulations, preference is given to Ugandan companies in the provision of goods and services. There's the therefore to understand what constitutes a Ugandan company. If you are a foreign investor coming to invest in the oil and gas sector, and the goods and services for which you seek to be provided in the sector cannot be provided by a Ugandan company, cannot be provided by a Ugandan company 100%, you are required to ensure that the Ugandan company has a joint venture with a foreign company, and a Ugandan company holding 48% of the shares. The question then is, what amounts to a Ugandan company? Can you engage any company that is registered in Uganda and say, this is a Ugandan company, let us have a joint venture? No. Under the relevant regulations, the Ugandan company must be the one that provides value addition to Uganda. Uses available local raw materials, employs at least 70% Ugandans. In addition to that, it is a joint venture with a foreign company has been approved by Petroleum Authority of Uganda. It is not enough to say you have entered into a joint venture with the Ugandan company. No, the joint venture arrangement must be approved by the regulator, Petroleum Authority of Uganda. So in reaching out a joint venture arrangement, there are certain things that the Petroleum Authority will be looking at. The venture must demonstrate technical and financial competence and be able to deliver the goods and services in a timely manner. Capacity to transfer knowledge and technology to Ugandan citizens. Demonstrate experience in the provision of the required goods and services. A company must fulfill all the above conditions. It is not enough to meet one of the conditions in order to qualify as a joint venture. The third aspect is the requirement of companies to employ and train Ugandans. The licensee shall, within 12 months after the grant of a license and on each subsequent anniversary of that grant, submit to the Petroleum Authority for approval a detailed program for recruitment and training of Ugandans. The program must provide for the training and recruitment of Ugandans in all phases of petroleum activities and shall take into account gender, equity, persons with disabilities, and host communities. These are the host communities in this context are the inhabitants of the district in which the petroleum activities is going to take place. As I indicated earlier on, investment of this magnitude requires social license. The host communities or the locals must support you for your project to succeed. The licensee is also required to develop and submit to the authority for approval a transparent policy and plan on training and employment of Ugandans, specifying the required minimum qualifications. A detailed plan for recruitment and training of Ugandan citizens in the activities shall include an outline of the hiring and training needs of the licensee, the licensee's major contractors with a breakdown of the skills required, the activity-specific training requirements, and the anticipated expenditure to be made directly by the licensee in implementing the employment and training plan. A time frame for employment opportunities for Ugandan citizens for each phase of the petroleum activity, and any other information that the authority may require. And on the ground, that's exactly what's happening. All other investors who are already involved in the sector are complying with it. It may appear complex and lengthy, but Petroleum Authority has developed what we call guidelines that the licensees or contractors are supposed to follow. In the event that you are not able to get Ugandans to employ and you are bringing expatriates, there's need for prior approval by the Petroleum Authority. The law provides that every licensee or contractor shall apply for a recommendation from the Petroleum Authority prior to making any application for work permits for the expatriates, the government, ministry, department, or agency responsible for immigration. Such application shall be accompanied with certified or notarized academic documents, curriculum vitae by recommendation certifying experience and job history referenced, a description of responsibilities, duration of the proposed employment in Uganda, evidence that Ugandan nationals are not qualified for the job, list of Ugandans identified for training, individual training plan for the replacement of the expatriates. The Petroleum Authority, being the authority with the mandate to regulate the sector, has a discretion to give the recommendation. It is not obvious that after making the application to be granted on several occasions, you can, in a year where you have 200 applications, you find that only 80 has been approved with a reason or deferred. The other aspect is the training, technology transfer, and capacity building for citizens. Under the Petroleum Exploration, Development, and Production Act 2013, Section 127, to be particular, a license shall include a clearly defined training program for the Ugandan employees, which may be carried outside or within Uganda, and may include scholarships and other financial support for the education. And this extends to training of government officials. Some of the players already in the sector have trained several Ugandans in this sector in areas of exploration, administration, technical aspects has already been carried out by the players. So any other player coming in is expected to comply. For the case of government, government officials have been trained in the Ministry of Energy, Police, Auditor General's Office. So every investor seeking to invest in the sector must bear this in mind. So the license must also include a commitment by the licensee to maximize knowledge transfer to Ugandans and to establish in Uganda management and technical capabilities and any necessary facilities for technical work, including interpretation of data. So what some of the players have done is to reach an understanding with the training institutions in Uganda that initially were training Ugandans in other sector, but with coming to play oil and gas sector, they decided to improve on the capacity, introduce on relevant courses in the sector. And many Ugandans have benefited from this. Finally, local content requirements are in form of measures that increase that focusing, that are focused at increasing use of the locally available labor technology and other resources in the oil and gas sector. A focus on transfer of technology by companies engaged in the extractive resource sector to set citizens with the hope of assuring them income, employment, and ultimately sustainable development. Participation of citizens in the oil and gas sector will require capacity building and training of citizens to work in the sector. Such training needs to focus on building capacity for direct employment and for services in the sector. So every company intending to engage in the oil and gas sector needs to equip itself with above requirements so as to ensure compliance. Thank you for listening. I will be on standby to answer any questions you may have in that context.
Thank you, Daniel. Thank you for this introduction into the concept of local content requirements with a focus on Uganda, and this gives a great introduction for us to now look at Tanzania. Was Madeleine Kimei, who will speak about navigating the legal risk and the local content requirements in Tanzania. Before I introduce Madeleine, I'd just like to remind all participants to please stay on mute, because there is a bit of background noise when you're not on mute, and that might be disturbing to all speakers. So let me now introduce, or last but not least speaker, Madeleine Kimei. Madeleine has many hats. She is the founder of iResolve Limited, a boutique corporate arbitration and dispute resolution firm, which also offers alternative legal support services. Madeleine has experience both representing parties and acting as arbitrator, mediator, and tribunal secretary in domestic and international arbitrations under the roles of TIOG, UNCITRAL, CASICA, and ICC. She is the current president of the Tanzania Institute of Arbitrators and chairperson of the Africa-Asia Mediation Association. She also serves on a number of committees and courts, including the ICC International Court of Arbitration, the LACIA Court of Arbitration for Tanzania, the ICC Africa Commission, the ICC Commission on Arbitration in DR, and the IBA Africa Arbitration Network. Madeleine, over to you. You have 20 minutes, taking us to 1:36 p.m. in Tanzania. Over to you, Madeleine.
Thank you very much, Ilham. Thank you for that wonderful introduction to this section where I'll be dealing and looking at and focusing on Tanzania. Allow me to share my slides. And I hope those slides are visible to everyone and I can be clearly heard. I mean, from what we have learned from the presentation that has just been made by my colleague Daniel from Uganda, really states at this point when the discovery was made, have a tremendous advantage to take in terms of now getting that that economic advantage to the local to the locals of Tanzania. Now in Tanzania, the definition for local content is provided for in the regulations, and it goes on to stretch to say that it's the quantum of composite value added to or created in the economy of Tanzania through deliberate utilization of Tanzanian humans and material resources and services in the petroleum operations in order to stipulate or stimulate the development of capabilities of Tanzanians and to encourage local investment and participation. Now, my presentation today is really focusing on the mitigation strategies and how one who is looking to enter the market and operate in the oil and gas sector can minimize and eliminate the legal risks associated to the application and implementation of the local content requirements, especially now that we are looking at the EUCOP project just picking up that is spanning through from Uganda to Tanzania. One can say that if one fails to effectively minimize the legal risks associated to the local content requirements, this could carry significant financial and legal and also reputational risks for those, not only the national authorities, but also the investors that are coming in and looking to be key players in the industry. Tanzania has had a national energy policy that has evolved over time, dating back to 2003, and we had an amendment in 2015, which touched on now these issues pertaining to local content related to this particular sector, which is the oil and gas subsector. The Petroleum Act of 2015 then provided for the fact that there would be regulations that would be enacted to touch on local content. Now, in view of that Petroleum Act and petroleum regulations, the licensee, contractor and subcontractors are portrayed as the main actors in the sector, and they're entrusted with numerous duties, responsibilities, and obligations to fulfill these local content requirements. It's very important to note that before entering into any business arrangement with contractors or subcontractors or licensees or any local or non-local company, an approval should be secured, of course, by the licensing authorities for both downstream and midstream. And that's provided for in the Act. And that's the mother act that we all go back to and fall back to when we're speaking on and advising on the petroleum sector. Section 219 that's in front of you says that a local company is considered to have 100% of the shares owned by Tanzanians. In case of a joint venture with a foreign company, then 25% of the shares must be held by a local company to be considered local. Now, this is what local is under the Petroleum Act. And then, of course, we have those subparts 11 and 30, subsection 2K from 4 to 6. There you have the use of local goods and services produced and provided in Tanzania. So this local content requirement trickles down from the main legislative statute to now the regulations, which are the Petroleum local content regulations of 2017. And these regulations were published under the government notice number 197 on the 5th of May in 2017. Now, these specifically provide now and requires operators to engage locally owned entities, provide for the ratios of the local ownership for such entities intending to provide services in the sector. The minimum percentage share requirements by the local shareholders are not only limited in cases of JVs, but also there are structures that, as you can see there, options provided for under Regulation 15 in terms of the ownership structure, which is really just the key issue that usually arises when a client is looking to come into Tanzania and wants to comply to these local content requirements. Now, in the course of the in that at that stage, then there's the option of having that the first and most preferred option, of course, is the acquisition of the goods and the works or the services, and then being locally provided or available in Tanzania. And then, of course, the second option under the local content requirements would be in the event that the goods and the services, and similarly to Uganda, that is, required by the contractor or subcontractor or licensee are not available in the country in Tanzania, then such goods and services shall be provided for by a company that has entered into a joint venture with a local company. And as I said, the qualification of a company to be local, as referred herein, is that a local person or persons should own at least 25% of the shares in that particular joint venture. And this all is entailed under Regulation 15. And then the third available option, as you can see there, would require a non-local company intending to provide the goods or works or services to a license or a licensee or and a contractor within the country to subject to the authority's approval and to enter into any business arrangement guaranteeing local participation of at least 10% of shares, interest, or equity, shares, interest, or equity of the contract value for the provisions of those works, goods, or services. There's also a fourth option whereby in the event that the formation of the joint venture or other business arrangements as prescribed in the preceding options that I've just mentioned fails, and upon application by the contractor or the licensee, the authority shall grant approval for the said applicant to source such works, goods, and services through any other arrangement which will provide the local company with the transfer of competence and technology. And so why is this important? In order to minimize and reduce legal risk for one that is planning to come into Tanzania. It's very important because when you're entering joint ventures or when you're forging partnerships in terms for in act to comply to the local content regulations, one must adhere to the processes that we are all aware of as legal advisors, which is conducting due diligence, conducting that preliminary assessment or preliminary investigation as to whom you are approaching to form these joint ventures. And this is what we're seeing here. There is that legal risk associated to these upcoming or newly formed joint ventures, all at aim to comply to the local content requirement in terms of resolving the issue of ownership of shares or equity in that manner. Moving on to the next item that I feel that there's a little bit of a job to look at in order to minimize the risk. Now, if we look at the local content regulation, it's also the responsibility of the contractor or licensee to prepare and submit a comprehensive content plan, which shall include or reflect local content plans of its subcontractors or any persons engaged to undertake the particular petroleum activity within their perimeters. The local content plan should correspond to the work programmer and the local content plan in respect of each year. And so there's that requirement of that submission of that local content plan put on the licensee and contractor. So how then do you ensure that you submit this comprehensive local content plan with the correct information? So there needs to be some sort of a compliance or local content compliance assessment or risk register whereby you, or requirement of submitting reports by your subcontractors to you in order for you to comply to Regulation 9 of the Local Content Regulations of 2017. And so the subcontractors or those investors who are coming in to play the role of a subcontractor, they then need to have a robust system in place to ensure that that reporting is being done in order for them, for the contractor and the licensee to be able to now channel through that information in that concise and comprehensive manner to the authorities and in a timely manner to that effect, because such submissions are also required on a yearly basis, as you can see there under Regulation 9, subsection 3B, where there's an annual local content plan. So that local content plan is a living document that will continue to embrace the changes of that particular project and align to what is happening on the ground. So those reports within 28 days need to be filed to the authority, and approvals or are usually rendered within the 60 days of the submission of the plan. In terms of the submission of the annual local content performance report, that's been done within 60 days beginning of each calendar year. So the timelines are very important, and that's why in order to minimize the legal risks associated with the local content plans, there has to be some sort of a risk compliance officer stationed either with the subcontractor and the contractor itself, or some sort of a dedicated team that would be able to ensure that these timelines are adhered to, because the regulations do have quite a number of timelines that one needs to, is an obligation to be able to comply to. And as we'll see later, if that is not complied to, then there could be offences that are mentioned under the regulations. It's also the responsibility to have a procurement procedure in place, as you can see under Regulation 31 of the local content plan. And the requirement entails the petroleum activities which are to be sourced, or where it is to be sourced by a competitive bidding procedure that is estimated to have at least over Tanzanian shillings equivalent of 100,000 United States dollars for upstream operations and 50,000 US dollars for midstream operations. These are the thresholds that have been set in order for one to ensure that there has to be some sort of a procurement process, a procedure approved for each contract or purchase order falling under those thresholds. Now, Regulation 43 also speaks on the statutory requirement for the contractor, the subcontractor, the licensee, to establish and implement a bidding process for the acquisition of the goods, preference to local company. It is mandated that the award of the contract should not be based solely on the principle of the lowest bidder, but the percentages are provided for therein. Now, with the EACOP local content plan, it's published on their website. It looks pretty much like it has, of course, gone aligned to the requirements under the Regulation 9, which requires there to be a submitted local content plan. And as you look there's also needs for those communication obligations under the regulations, which are compulsory for the contractor, subcontractor and licensee to communicate the local content policies, procedures, obligations, requirements to any persons engaged by them to perform any aspect of the petroleum activity. And so therefore, we fall back to there having been need for having a compliance dedicated team with regards to local content. Now, looking at the service providers, we have an LSSP, it's referred to as LSSP, under the Energy and Water Regulatory Authority, AWURA, for which AWURA is now vested with that general power to form this database or the common qualification system. And so this particular system requires that pre-qualification of companies that meet the local content requirements. And I won't speak a lot about this, but what we have seen is that the evidence of one being compliant is not an issuance of a certificate, but it's really just a database where you go to the website and you have a list of companies. And at this point in time, as of June 2021, you've got 737 approved local entities on the LSSP database that can then provide services within the industry because they've done that pre-qualification process. And AWURA is satisfied that they meet the local content compliance. We'll move on to the next slide. In terms of workforce, the potential risk here of having sufficient availability of local capacity to fit the levels established. And, for example, the following under the key to EACOP's achievements: local community, employment and training, meeting or exceeding the regulatory targets for employment and training of Tanzanian personnel, technical and other staff, training of Tanzanians in the sectors targeted for priority development or oil and gas disciplines. And so this can be reflected on the local content requirements in terms of workforce. And however, notably, if we look at the pieces of legislation that are attached to workforce, which is now, let's say, the Non-Citizens Act. The Non-Citizens Act requires that first law that would impose limits on the foreign participation in economic activities in Tanzania, placing limits on work permits for foreigners and also requiring for resident permits and the likes. Now, these have to be read together, and a plan for succession plan also is required for those processes where you are obtaining a work permit. And so there has to be alignment in terms of the local content plan, where you have your succession plan embedded therein. That needs to tally with your application for work permits for those foreign workers that are coming in under the project. Moving on to the fiscal incentives, here the potential risk is that at this point in time, there has not been put in place any regulations with regards to the fiscal incentives that are mentioned in the regulations under Regulation 19, subsection 2. These fiscal incentives really touch on taxation, royalties, and tax treaty impacts on these kind of projects, and the potential risk for companies to exploit fiscal incentives that under that regulation is at this point not exploited to the fact that we do not have those regulations in place. And so the analysis for those companies looking to come into Tanzania for purposes of rendering services or goods within this sector now, they would need some sort of guidance in terms of those tax treatments or royalty issues that arise from that investment. And of course, then that is a network of legislation that could cause a bit of a toggle to go through. There are exemptions provided for under the regulations. The parameters exemptions have not been set clearly though, because as you can see there, granting broad exemptions reduces the credibility of these local content strategies and therefore risks the achievement of its main objectives. Of course, well-defined criteria would be granting of exemptions are also necessary to reduce those discretionary powers that are vested in the authorities and institutions that take part in enforcing of these local content plan requirements. We look at the local content regulations and we see offenses and penalties. And so when we're speaking of legal risks and trying to minimize legal risks, we're really looking at the back fall if we do not manage to minimize and ensure that we are fully compliant. Then there are these offenses that are set out under Regulation 47, and they are very comprehensive and offer severe penalties that are associated to infringing such provisions, including a defaulter not being able to participate in tenders. And so one would want to look at if anyone fails to, for example, comply with the minimum local content levels for any petroleum activities in contravention with that Regulation 29, or employ Tanzanians in semi-skilled or unskilled labor in contravention of Regulation 14. All these attach to them some penalty of some sort. Now, in terms of legal risk mitigation strategies, as mentioned earlier, one needs to perform the compliance risk assessments and develop and implement compliance policies and controls or procedures for local content transactions. Local content partners must be subjected to appropriate integrity diligence. And so those partners that you're looking to partner with need to be well investigated prior to you entering into any sort of a forged joint venture of any sort. Now, implementation also in terms of ensuring that you comply to several obligations under the regulations, then have that oversight plan and be proactive in addressing compliance issues that are arising from the local content requirements. Given that the natural gas sector is just beginning to develop in Tanzania, and it will take, where we can see that it will take many years for that competence to build within the sector, and especially on local content requirements. So although the local content requirement regulations are comprehensive and robust, but there is still need for sensitization, and this sensitization and training are being conducted by the authorities and associations that are attached to the oil and gas sector. And so that is in itself pleasing to see. And we look forward to any questions coming in from the perspective of Tanzania. Thank you so much.
Thank you, Madeleine, and thank you for keeping to time. I've had really well-behaved speakers today, so I haven't had to do a lot of moderation, which I'm very happy about. Can I ask all speakers to come back on camera for the Q&A, and for the participants who wish to come on camera, please feel free to do so. We were planning on having an interactive Q&A. So I got 3 questions, 2 from Susan Rattray and 1 from Philip Alika. Susan, can I give you the floor first to ask your question?
Thanks, Ilham. Lovely to see the all the speakers and the number of participants here. I'm freezing in Zambia, so I'll ask my questions quickly and turn off my camera. First question is to Jinlin. So I am a DAB practitioner as well, and I serve on the EPC contracts. And you have, the interesting suggestion you have made of in terms of risk management for splitting EPC contracts for offshore and onshore portions. Where do you see the DAB sitting in those scenarios? Would you be proposing to have several DABs depending on where you split it, or are you proposing that we maintain at the head agreement the DAB, which then is going to be dealing with offshore contracts as well as onshore contracts? Because of course the DAB agreement is tripartite with the contractor and the employer. So what's the implications for the DAB in terms of this idea of splitting the EPC contract?
Yes, thank you for your question. And normally there are 3 agreements or 3 contracts: onshore, offshore, and boilerplate or umbrella. Keep all these items, not fall into onshore, not fall into offshore. We keep them in the umbrella agreement or boilerplate agreement. So that would be in that part, DAB.
So then you will be signing with the tripartite agreement then between the DAB member and the employer, and who is sitting at the head of the EPC in the boilerplate, and only at that level, and then having to manage to perform the dispute avoidance functions as well as resolution through permeating through the flow-through agreements. Is this the idea?
Yes, the principle of freedom of contract still exists there. So everything you can put into the agreement so far as agreed under the principle of transparency and openness, because that is a compliance requirement. So far as you keep transparency, openness, and that under the principle of freedom of contract, you can put that there. So normally we put into the boilerplate agreement or umbrella agreement, so that to contain or remain the rest items which not split into either of them. But even though we still normally keep the arbitration clause and the DAB clause into separate agreements, still keep them, not move them out of the onshore or offshore, still keep them in the onshore and offshore agreement. And also the boilerplate agreement would have such an item, all the party, either onshore or offshore, because they will sign together jointly as EPC consortium members, and sign the boilerplate agreement that all the members of EPC or the onshore offshore parties should be jointly liable to the employer. You know that.
Okay, thanks. Yeah, I can. I mean, from the operational side of it, I can see the complications for the DAB members in terms of how we are performing the avoidance services through the flow-through agreements. But yes, in terms of, I mean, my preference of course, would be to have a single DAB to manage the the whole process throughout. But thank you for that, Janine.
Single person would be very heavy work.
Yes.
Because too much work. It can be one person, it can be three persons. Each party join point one and selected potential arbitrators or DB members select the third one as chairman. No, this is a normal practice. But for one person, the work is too much. Too much. He cannot do that because sometimes you need a very speedy, very quick decision. Then
of course, we also have the issue of the different expertise required in the different agreements. So I mean, sometimes I have seen that it is even more than three. And of course, when we get on to the O&M contract, it's another bunch of skills. So yeah, it's quite. I mean, it's a very exciting process, but it can become quite complicated on the extensive, very large EPC or PPP contracts, which have very many elements. And I'm sure the oil and gas things coming through in East Africa will fall into this kind of category. So it'll be interesting to see how it develops. Thank you.
Thank you.
Thank you, Susan. Thank you, Janine.
Thank you, Susan.
Moving on to the next question we got from Philip Bellica to Madeleine. Philip, do you want to ask your question directly, maybe?
No, thank you. It's on the screen. You can read it.
Okay, I'll read it. No problem.
Yeah. So, Philip, I was just in the process of getting back to you. Apologies, I had closed my chats, unfortunately, and I'm just seeing it now. But just as advice there, at this moment in time, yes, the East African community, we are having that free movement. However, a Ugandan coming into Tanzania would still fall under the Non-Citizens Act. And so therefore they would still require the prerequisites, which is having to have the work permits issued and the likes. Now, in terms of being local, under the local content regulations, that would not suffice because the local bit is purely directed to their being a Tanzanian citizen. Now, when you go back to the Citizenship Act, the Tanzanian citizen is properly defined there. And so we don't have dual passports yet. And so we cannot have a Ugandan who's also Tanzanian, unfortunately. So at this moment in time, the local contents are pure indigenous parties.
Well, I also, if I may, I've asked you a second question, which is whether or not, if I may, moderator, it relates to the Natural Wealth Resources Permanent Sovereignty Act and the prorogation of jurisdiction to Tanzania. And I was just curious to know whether or not arbitration clauses would necessarily have, or whether or not one would have to have a dispute resolution within Tanzania. In other words, the effect of the legislation is to prorogate to Tanzania all disputes involving natural wealth. The particular resource in question here would be public land, Tanzanian public land. Could you have an overseas arbitration clause in a contract relating to this particular project?
Yes, you could have a dispute resolution clause. And the Natural Wealth or the Natural Wealth Act under Section 11, if I recall correctly, does provide for such arbitration to be done within Tanzania or with a tribunal that is established in Tanzania. Now, with the amendment that was done in 2020 under the Arbitration Act of 2020, there were several amendments that were included, which then went away with the word established and just left it that it's within Tanzania. And so when we speak of arbitration and we look at the seat and the venue and the fact that you may elect the seat of the arbitration to be Tanzania, but the venue doesn't have to be necessarily Tanzania. And so this is the approach that is the policy that is being driven under the National Resources Permanent Sovereignty Act, is that, yes, the seat would have to be Tanzania because of the public nature or the public policy nature attached to natural resources, attached to public land. And so therefore, one would have to agree to the local national laws of the country. Those will be the curial laws that would be applied to that arbitration. And so where we were before, of course, that was a little bit of a change management problem, where we couldn't have that effective communication as to the policy, what they wanted to be done, basically, what they needed to be taken out of that interpretation of that statute. But rightly now, what we're seeing, the application coming from the Solicitor General's office, the agreements that are coming out that are attached to natural resources, are agreeing to the seat being Tanzania, but then you can be really anywhere. You can agree to ICC arbitration in Paris, as long as the seat is Tanzanian law.
Yeah. I think you answered the question. Thank you very much indeed. Thank you.
Thank you.
Thank you both. Virginie, we got a question from a member of the ACL who just dropped off on currency fluctuation. So Jinlin covered currency fluctuation and how it can adversely impact the cost of a project and payment to contractors, among other things. What is your advice to parties to mitigate such a risk? You're on mute, Virginie.
Thank you, Ilham. Thank you. I thought, I will answer your question, but I thought the question from Philip was also relating to Uganda law. So he was asking the same kind of aspects, not only under Tanzanian law, but also Uganda, if I'm not mistaken. But in any event, there's a currency fluctuation aspects. It is essential to anticipate those kind of risks, and they are typically negotiated at the time when the contract is defined between the parties. And when entering into an agreement, the contractor agreed to perform one or more obligations in exchange for payment in the currency specified in the contract. And the contractor typically bears the risk of exchange rate fluctuations that may affect its cost or the amount agreed upon in the contract. However, the position of the contractors will depend on many factors, including whether the currency of valuation is the same as the currency of payment, which is not necessarily the same. And whether an exchange rate is fixed, and whether, for example, the contract includes a price adjustment mechanism. In addition, the parties may agree to include one or more specific clauses in their contracts to allocate and mitigate the risks associated with currency fluctuations. And for example, the parties may include a risk sharing clause, providing that any loss caused by a currency fluctuation above a certain threshold will be borne equally by the parties. And the parties may also decide to use, for example, an indexation clause, which links rate movements to the performance of an index. And finally, I have to say that many contracting parties relate to the imprevision or the hardship or force majeure clauses or implied terms in order to get out of a situation where the exchange rate may undermine their profits from a contract. But unfortunately, I have to say that the application of force majeure or the application of hardship or clause or implied term is very, very difficult because the percentage of change that would justify a force majeure or hardship implied term must be extremely high. And that there are some cases where the increase of about 30%, between 30% and 60%, have been denied in, for example, in France, has been justified by, has been justifying a readaptation of the contract. So, and the inclusion of an indexation clause makes even more difficult the possibility of invoking the application of a hardship or a force majeure clause. So, my conclusion is that it's better to actually try to negotiate this kind of risks at the very beginning, at the time of the negotiation of the contract.
Thanks, Virginie. So the last question will indeed go to Daniel, and I won't put Susan through the trouble of coming back on screen since it's freezing in Tanzania. So the last question, Daniel, which is from Susan, is the oil and gas sector in Uganda going to be exempt from the African Continental Free Trade Agreement Protocol on Free Trade in Services? And what are the implications for the vision of the African Continental Free Trade Agreement? Daniel first, and then if we do have 1 minute left, Madeleine, I might ask you to give us a Tanzania perspective on that before closing. Daniel, over to you.
Thank you. To the best of my knowledge, I'm not aware if that exemption will apply. Hello?
Hi, Daniel. Then thanks. That was a short answer. Daniel, might I follow up with a question I had on the Ugandan regulations on local content? So I do understand that the aim of those regulations is to ensure that, among other things, Ugandans benefit from the development of the petroleum sector in the country. But I was wondering, you spoke about those programs that stakeholders and contractors would need to submit to the authorities. What is the standard that's referred to by the authorities when reviewing such programs, and how do the Ugandan authorities plan to monitor the implementation of those programs?
Thank you. The sector is regulated by Petroleum Authority of Uganda. So one of the mandates is to monitor and regulate activities as a whole in the sector. On the standards, it has developed what we call checklists, and it all varies depending on the activities of the company at hand. So this varies depending on, as I said, the activities you are going to undertake. But it also monitors by requiring the company to submit annual and quarterly returns or reports on their compliance measures. The question is whether those reports reflect what is on the ground. Now, as of now, the authority is able to conduct field visits, okay, to confirm that indeed what the companies have submitted in their reports is actually what's on the ground. So for now, the companies are not so many. The Petroleum Authority has the capacity to visit all of them and verify. And maybe in future, maybe when the companies increase as the activities begin to pick up in the sector, maybe that's why we have challenges. Otherwise, for now, they have the capacity to monitor and ensure compliance. Thank you.
Thank you, Daniel. We have 3 minutes left. Madeleine, can I maybe ask you to come in here and similar questions? What efforts have been made in monitoring and evaluating the local content requirements in Tanzania?
Thank you, Ilham. I think, from what Daniel has said, the same efforts are being made by the authorities here. That is, we have two regulatory authorities, one for upstream, one for midstream. We've got AWURA, which is the regulatory authority that is charged with maintaining the legal service provider database, or CQS, if I can recall the acronym. And that has been well established, meaning that the pre-qualifications for local service providers has been established and it is ongoing. And the checklist is there in terms of ensuring that the local service providers are meeting the local content requirements within the sector. Again, if we look at the authorities, there have been formed several committees, the local content sector committees that are sitting under the Ministry of Energy. These local content committees are charged with ensuring that that monitoring and evaluating the effectiveness of implementation of the local content regulations for those existing petroleum players. And of course, the challenge there is ensuring that the reporting is being done, ensuring that the plans are being submitted, and ensuring there is onward follow-ups in terms of those that have not been able to comply to date. And there are several who have not been able to comply to date in terms of the local content aspect of things. And so that engagement with the committees that have been created specifically for monitoring and evaluating local content implementation is where we are saying that, okay, yes, it's the start, but with that having been formed, it's a good starting point to have such a committee in place.
Thanks, Madan.
That's all from me.
So it's now 3 p.m. on my side, so 12 in London, and it is time to close. I thank all the speakers for the excellent presentation and for covering all the questions put to the panel, the participants for joining us, and for putting questions to the panel as well. It's been really good having those 20 minutes to address those questions and have discussions as well. We will be circulating the slides the speakers covered during the event. ACL will email those slides to all participants. And if you want to continue following the developments of ACL and ensure you have access to our events and publications, I recommend that you register as a member. So I'm just putting on the chat the link to the website allowing you to register as a member. So on behalf of ACL, I will close the event and thank you all for your participation.
Thank you, Ilham. Thank you, everyone.
Thank you, Ilham. Thank you, everyone.
Thank you, everyone.
Bye.
Thank you. Bye. Keep well.
Bye.
Bye-bye.